All right, we want to turn back to the big redistricting case before the Supreme Court this morning. CBS News chief legal correspondent Jan Crawford joins us from outside the courthouse with more on all of this. Jan, good morning. So help our viewers understand what exactly is being decided here and why these justices are actually hearing this case again.
Well, that's right. I mean, they did try to decide this case in their session last term, and they held off to really look at what could be one of the biggest constitutional issues they'll take up this term. Really what we're talking about here is the Voting Rights Act of 1965, that 60-year-old law that was passed at the height of segregation, and one part of it in particular called Section 2. Now, that provision of the Voting Rights Act can require states to draw up legislative districts that sometimes zigzag across the state, grouping voters together based on their race, to draw up a majority black district. That's all to increase minority representation, and advocates say it's had an enormous impact in doing just that, increasing minority representation. But a group of white voters challenged a second legislative district in Louisiana. They say it's unconstitutional, that you're not supposed to consider race. The government's not supposed to consciously sort people based on their skin color. So that's kind of the convoluted question that the court will take up today, but it could have dramatic implications, Errol, for how states draw up their legislative districts. The political implications of this are huge.
And Jan, you actually spoke with Louisiana's Attorney General about this case. Let's just quickly play for our viewers some of what she said.
The Constitution has told us to not sort people by race. The courts have told us we can't sort voters by race.
Tell us more about the state's position and the potential precedent a ruling might set in this case.
Well, the state is now saying that having to draw up that second majority black district, which a court ordered it to do, that's unconstitutional, and that dividing people up based on their skin color, even if it may be for a noble intention, that's not the kind of discrimination that's permissible under our Constitution. It only fuels racial divisions. That's what they argue, and that the time has come to really stop classifying people based on their race in this country, that people in Louisiana can win elected office without those majority black districts, and that's where we should be today. So they're going to make that case, but of course you're going to hear arguments on the other side that this is not the time to abandon the use of race, and that this country has not moved past that, Errol.
Yeah, we'll have updates on this throughout the day. Jan, great to see you. Thanks so much.
Okay, so just moments ago, the United States Supreme Court wrapped hearing oral arguments in a high-stakes case that could have major implications all across the country. So the justices debated a challenge to the Louisiana redistricting map effort. At the center of the argument, whether this new map violates a provision in the Voting Rights Act that bans racial discrimination in redistricting efforts. You're looking at it right there. So leaders from Louisiana expressed some pretty major frustrations, not only about the map, but the process. And then look at this. Outside, demonstrators took those frustrations to the steps of the U.S. Supreme Court. Right there, you see on your screen through our monitors, that was the scene as so many people knew on the inside those oral arguments began. In fact, you see the signs there, unfair maps equal white supremacy, some pretty heavy statements there outside. Signs and shirts calling for the end of what they believe amounts to voter suppression, with phrases like Black Lives Matter, Black Voters Matter, Protect Our Vote, and Protect People, Not Power. So just moments ago, Louisiana Attorney General Liz Murrill spoke about the arguments before the justices. Listen.
So we've said all along that you have to look at how the population is distributed and look at how maps can be done legally and constitutionally. And that was the basis on which we defended the first map that we drew that was part of the Robinson litigation. And so, you know, I think that we've been over and over this argument about proportionality. Proportionality is not the test. And so, you know, I think we are all bound by the rules that apply. And the court has made that even more difficult with confusing precedent on telling legislatures what they can and cannot do.
So moments ago, there's another side of this. Lawyers from the Legal Defense Fund also spoke out. We wanted to let you hear their remarks.
Just leaving the court after arguing Louisiana versus Calais, where the court asked some very challenging questions about the future of Section 2. We feel confident that if the court relies on its precedent, if it continues to have a commitment to the 15th Amendment and to this project of multiracial democracy, that it will rule in our favor. There has been no change in conditions or the law since it decided Allen versus Milligan a mere 28 months ago, where the court reaffirmed the constitutionality of Section 2, where the court rejected many of the specious arguments that our opponents have asserted on this second argument of the case. And so we feel very confident that the law is absolutely on our side. I want to take a moment, though, to thank our plaintiffs who have continued this fight, this battle, not only for fair congressional maps in the state of Louisiana, but fair legislative maps, fair judicial maps. It takes the will and spirit and courage of everyday people and voters to put themselves on the line, to commit themselves to often a very long and protracted project of ensuring our democracy. And while we are fighting for the rights for Black voters in Louisiana and across the country to have an equal opportunity to participate in our electoral process, that win is a win for democracy. It is a win for all Americans. It is a win for the rule of law. And that is why we fight, because we believe in the future of this country, and we believe that Black people have a right to be part of it and to self-determine who will represent them and to be part of the future of this country. And that is what Section 2 of the Voting Rights Act secures, and I'm happy to take your questions.
All right, so that is the after and what happened outside, but let's bring in CBS News legal contributor Jessica Levinson, who listened to the arguments on the inside for several hours. So what's the focus, and are you getting from the justices in any of their questions sort of a sense of where they're leaning, Jessica?
I think we're getting a sense over 2.5 hours of questions, Reed. And as you said, this is a hugely consequential case, and it asks us about the continuing strength of Section 2 of the Voting Rights Act, which generally speaking prevents vote dilution on the basis of race. So I want to kind of focus everybody, I think, on the conservatives, because it seems clear that the liberals are comfortable upholding Section 2 as it exists, and more specifically, upholding the cases that interpret Section 2. So when it comes to where the conservatives are, I think that there might be some disagreement about whether and to what extent race can be considered when drawing in the first instance or redrawing in the second instance district lines. And Reed, I think it's really hard to read the tea leaves here, but it looked like towards the end of the arguments that there were justices who were coalescing around a proposal that the Department of Justice had provided, which is essentially I don't want to say compromise, but more of a middle ground where maybe some of the precedents are, as Justice Barrett said, weakened, or she said clarified or modified. I would argue maybe weakened, but that Section 2 remains as part of the Voting Rights Act. It remains as a protection for individuals and their voting rights, but that it might be harder to bring those cases, and some would argue harder to remedy violations.
Well, we know not only Louisiana grappling with this, but many, many states, including the state of California and others. And if other states hinge it on this same question about the Voting Rights Act, as so many protesters outside do, is the Voting Rights Act at stake here?
Well, we have to see. So what happens in Louisiana will determine what happens to the Voting Rights Act everywhere, because of course this is about Louisiana. This is about a situation where Louisiana drew district lines where there was one majority Black district. And there was a finding by the district court that there was a likely violation of the Voting Rights Act. So Louisiana went back and drew lines where there were two majority Black districts. And that's the case that has gone up and down and is now the case we're talking about that was heard before the Supreme Court. But it's, of course, not just about Louisiana. So depending on what the court says and depending on how strong Section 2 continues to be, that obviously applies to every state throughout the nation. And I have seen political scientists indicate that if the justices do significantly weaken, let's say, the power of Section 2, that could allow Republicans to draw district lines that would essentially lock in a Republican majority of the House, potentially for decades. So this goes well beyond Louisiana when it comes to consequences.
All right, Jessica Levinson, always great to talk to you. Thank you so much.
And CBS News election law expert David Becker joins us now. He's also the executive director of the Center for Election Innovation and Research. David, thanks for being with us this afternoon. So how does this case actually impact who gets to vote and how much their vote counts?
Yeah, in a state like Louisiana or in many states, Black voters or minority voters form a minority of the voting population. And we see in some states like Louisiana, where the white voting population tends to vote differently than the Black voting population. In other words, the candidates that Black voters prefer are being defeated by white voters for a variety of reasons. And this is, of course, exactly what the Voting Rights Act was designed to protect against. It was designed to implement the 15th and 14th Amendments of the Constitution to prevent that kind of activity and effectively shut minority voters out from any representation. And it's unusual here that the Supreme Court, where a majority of justices have already enforced the Voting Rights Act, a majority of justices currently sitting on the court, as recently as a couple of years ago, are now considering whether that act might be unconstitutional 60 years after its implementation.
Yeah, certainly one to watch here, David. If the court does end up siding against Louisiana, though, what kind of response could we potentially see from other states?
Well, I mean, we could see states where, with large minority populations, backtrack and go back to the days that we used to see before 1965. It's not that difficult, if there's no restraints like the Voting Rights Act around there, to essentially what's called crack minority populations. You might have a state with a roughly 30% Black population, and then you could draw districts that basically have 30% of Black population in each of the districts, meaning that the candidates that Black voters prefer would never get elected. That's exactly what the Voting Rights Act was intended to prevent against. And it's worked remarkably well, particularly in states like Louisiana, where we still see that kind of racially polarized voting.
So, David, this is all happening against the backdrop of states like Texas moving forward with redistricting plans of their own. It's been a busy season for that. Talk to us about how this all relates to gerrymandering. Could there be a problematic effect on minority voters overall?
Yeah, we should note the Voting Rights Act is not about protecting Democrats or Republicans or protecting the rights of minorities to vote for Democrats or Republicans. When I worked for the Department of Justice under two different administrations, I sued both. I mean, that happens all the time. But it may be in this era where both parties are trying to squeeze out every last district because that majority in Congress is so narrow that one restraint that said you could not dilute the minority voters' ability to elect candidates where they were large enough to form a district. That's going to be gone, and we might see states do even more redistricting, change lines more often, and we might see a reduction in the ability of minority voters, Latinos, Black voters, et cetera, being able to elect candidates that they think represent them.
David Becker, thank you very much for joining us.
What could happen? What would the results on the ground be?
I think the results would be pretty catastrophic.
Janai Nelson, president of the NAACP Legal Defense Fund, argued Wednesday that Section 2 of the Voting Rights Act is crucial to maintaining Black representation in Congress.
We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act.
But lawyers for the state of Louisiana and the Trump administration strongly disagreed, saying Black candidates are winning in Louisiana and elsewhere in non-majority Black districts, and it was time to stop grouping voters based on the color of their skin. Like with this Louisiana map, which critics say is unconstitutional because it relied too heavily on race to create Black congressional districts.
You have to create a district for Black Democrats that you would never create for white Democrats in a Republican state. It's essentially being used as a reverse partisan gerrymander on purely racial grounds.
CBS News legal contributor Jessica Levinson says the court's conservative majority may find a middle ground, but one that could still reach far beyond Louisiana and significantly change Congress.
Political scientists that I've looked at, who I've looked at their studies, say this would be a big boon for Republicans and could potentially lock in a Republican majority in the House of Representatives for years, maybe decades.
The Supreme Court isn't expected to deliver a decision until next spring. Jan Crawford, CBS News, Washington.
And let's bring in now Jessica Levinson, our CBS News legal contributor and Loyola Law School professor. Jessica, very good to have you here with us. Let's talk more about this because this case deals with Section 2 of the VRA, the Voting Rights Act. Can you explain what that is and how it has been interpreted so far?
Absolutely. So this is part of the landmark piece of civil rights era legislation, and it's really the only part of the Voting Rights Act that's still standing. And briefly, it prohibits voting practices and procedures that dilute the right to vote based on race, color, or membership in a language minority. And the way it's been interpreted has changed fairly recently. Back in 1982, Congress amended Section 2 and said that a violation of this section of the Voting Rights Act is not just based on intentional discrimination, but also based on effects. So even if you don't intend to dilute somebody's ability to vote based on race, if you have, for instance, district lines that have that effect, then you might still have a violation of Section 2. Right now, as I mentioned, Section 2 is really the only part of the Voting Rights Act that still stands because back in 2013, the court essentially hobbled the other half, Section 5. So it's been doing a lot more work, arguably, than it used to.
So, Jessica, what then is the legal argument that they're making for getting rid of Section 2?
So the legal argument here is, well, there's a number of different questions, but I think what they boil down to is, one, when do you figure out whether or not you have a Section 2 violation? And there's this case called Jingles that the court has relied on for a long time. And there is a question, and the Department of Justice put this to the justices as to whether or not that particular test should be clarified or modified. And then two, there's a question of if there is a Section 2 violation, can you take race into account when you're drawing district lines that try and remedy that violation? And that's really the question at the heart of the Louisiana case. And that's what happened in this case, where a court said, we think it's likely there's a Section 2 violation. Louisiana redrew district lines. And then the challenge was you considered race too much when you drew those district lines.
So, Jessica, this is all happening as at least 9 states have passed their own versions of the Voting Rights Act. If the Supreme Court changes this federal law, would this affect those individual states?
So this is really about an interpretation of federal legislation, and it's really about when you are trying to remedy Section 2, as we talked about, do you bump up against the 14th Amendment Equal Protection Clause if you consider race either at all or too much? Could it have implications for how we later look at state versions of the Voting Rights Act? It could, but it really is about just looking at this piece of federal legislation and trying to figure out what it allows.
All right, Jessica Levinson, thanks for helping put some of this into context. We really appreciate it.